Do you want to study law? Hi, I'm Sherry. I'm a realtor. I recently started my study in law. Let's recap what I've learned in first week. Governor-General in Canada represents a monarch. It shares responsibility with the Parliament. Parliament consists of House of Commons and Senate. It has the legislative and statute power. Every province in Canada except for Quebec is a common law system, which means judges can make law. They make new law when they interpret it, when they decide, or when there's a need for a new remedy. This new law may be upheld by a higher group of judges sitting together on a pier. A new law upheld by the Supreme Court of Canada becomes the law of the land. Quebec is different from Ontario. Quebec is like many European countries. It has a civil law system, which means its law is based on a system of authoritative legal codes. One way to categorize law is by substantive law and procedural law. Substantive law is about the contents of the law, such as the Residential Tenancy Act. Procedural law is about the rules and process involved in the law, such as when to file the notice. In tort, 4 elements need to be established for a negligence claim: the duty, the breach, causation, and harm. You owe a duty to the customer, which is a reasonable expectation of standard of care, and you breach that duty, which caused harm to the customer. Then they can establish a negligence claim. There are 2 tests for the causation. One is but-for test. But-for test is a very loose test, such as, but before I go to the bar, I will not be overserved and have the accident. The other test is called the approximate test, which is the closest reason for the injury. In US, some states use the but-for test. That's why there are so many high-cost liability claims in US, but for Canada, we adopt the approximate cost test, which is more strict. That's all what I have learned in week 1. Let's continue for next week.